Hi Dragons, now we're on part 4 of the jury. So different dynamics affect the jurors as well. So as we talked about before, the size of the jury, and remember we talked about 12. And in the book it says Henry II jury was 12. The number 12 has different magical abilities about it. 12 apostles, 12 tribes of Israel, 12 patriarchs, 12 officers at Solomon's court, 12 months in a year, so 12, 12, 12 is a big thing. And, we don't like the number 13, so we're going to go with 12. So it has a lot of significance in our folklore as well. And the case was decided to have a diminution of the jury from 12 to 6 in Williams v. Florida. Okay, and the logic behind that was, of course, money. It's going to be a lot less costly if we go from 12 to 6. So that was decided. The Supreme Court looked at the 6-person jury, but then said not less than 6 in Black and Blue versus Georgia. They said fewer than 6 would be unconstitutional. I don't know how they decided that. They just decided that. They didn't do any research. They just said, we're the Supreme Court. We're going to make that decision. So do smaller juries give the same sort of decision as larger juries? Well, the one thing is that smaller juries are faster, which indicates that they're not giving as robust a discussion and evaluation of all the possibilities of evidence that is before it. And we also talked about decision rules. A decision rule is how do you decide a case based on how many members must agree before the group decides to reach a decision, okay? And so we have majority rules and we have unanimity, okay? So here's a question that was before the Supreme Court in, what case was that? Johnson versus Louisiana. So in this question, if our jury of 12 only needs 9 people to reach a verdict, because that would be majority, will an initial vote of 9-3 end up in deliberations? Because, if you do a straw poll, remember I told you when the jurors go in, after hearing a case, they do a straw poll to see where they are. So does that mean that we don't even need to hear the case because it's already 9-3? And, logic would tell you, yeah, hey, there's a majority. We don't need to do it anymore. But the Supreme Court said that would never happen. That would never happen because there's a magical person on the jury. They literally were talking about this person and who they named the conscientious juror. And the conscientious juror would say, no, we have to deliberate in every occasion. Okay, the conscientious juror would somehow magically appear and push for deliberation when you already had a 9-3 majority to begin with. Okay, so social scientists and psychologists, forensic psychologists and mathematicians think that's very unlikely because there will be a lot of types of people like the satisficers who don't want to, really do much about that. We also have social loafers on the jury. They just let other people do the work of the jury and deliberation, and they're like, yeah, I'm just going to go along with the majority. So they're not likely to be they're not likely to be the conscientious juror. Okay, so we do have people called nominal jurors, and nominal jurors are people who take the jury service seriously, the conscientious jurors, and they end up doing the bulk of the work in terms of deliberation, analyzing the evidence, looking at more than one possibility. And the nominal jurors will do most of the work. Let's hope that every case has a nominal juror, which who knows, they may not. They may end up with a bunch of social loafers on the case. They may just go in and take a straw poll and go, hey, we got a majority, we can all go home now. Or they may have some satisficers who say, okay, that's enough, that's good. None of us want to think that justice will be meted out that way. We hope that everyone who's on a jury will take that oath of the jury seriously and, go through the evidence and do the best that they can. But like the Supreme Court says, but the research doesn't bear that out. So also what will happen, because the jury is a group, and as you remember from social psychology, once you're in a group, there's a lot of pressure to conform. Okay, so there's a lot of pressure on a jury to conform to the majority and all of that sort of thing as well. So, we talked about what happens. Is a 5-1 the same as a 11-1? And no, it's not, because you don't have that true partner who will side with you. And when we look at the case of the 12 Angry Men, I don't know if you've ever seen that movie, but it's a classic, right? Here they are in the jury room, and 11 of the people agree, and they're sequestered too. there are 11 people who are agreeing, and then there's this one minority opinion who's sitting there saying, no, and I'm not going to change my mind, and then one minority opinion ends up changing the group. Well, group dynamics would tell you that is not the case. Okay, that almost never happens, and it almost never happens in a real courtroom as well. But there have been cases where a very persistent one lone minority opinion can change the whole group. It depends on the perception of competence of that one. Is that a really competent person? So someone who, does not seem very competent or seems unsure of themselves will probably not change the majority. But someone who is insistent, relentless, competent, and very confident in what they're saying have been shown to change the jury on occasion. Statistically, does it happen often enough? No, it doesn't happen very often. But it makes for a good movie. Now you know the reality of it. So don't have your family see that movie, and then you're in there saying, you're also there saying, that will never happen. It's a statistical rarity. Don't spoil the movie for your family. So, during deliberations, what are the kinds of events that happen? First, information of guilt or innocence is exchanged. You have the straw poll. Second, there's a lot of persuasion. There's a lot of that kind of thing that's going on. And third, the pressures of conformity are the things that are happening as well. Usually, what happens in reality is that with a jury, there is a leniency bias. Okay, not juries that have authoritarians on it, but in general, jurors are much more lenient than a judge. Now, does that fly with Calvin and Zeisel found in the American jury? Remember, they did their analysis of all these jury cases. No, it doesn't. Generally, juries are more lenient, okay? And that is because, as Calvin and Zeisel explained, that judges know information that juries do not. They know, past deeds of a particular defendant, especially if that defendant is a repeat defendant. They know how many times they've appeared. They know their rap sheet. They know all of that sort of thing. So that may be a reason why juries are more lenient. Instead, they buy the certain things. There are exceptions, though. Calvin and Zeisel's research showed that if a case is particularly heinous, okay, or it's like something like that really offends the sensibilities of the common person, like child sexual abuse or things like that, usually juries are much more conviction prone in those types of cases than a judge would be. So I guess it depends on the type of case. And Calvin and Zeisel, if you've ever want to look at those types of decisions, they pretty much outlined the types of cases where a jury is better versus a judge is better. So if you're ever, find yourself on a jury, find yourself as a defendant, you might want to pick up a copy of that book. I have it. You can you can look at it. So there's another thing that happens with majority and minority called the social decision scheme, where it looks at pre-deliberation majority win and split decisions toward acquittal. Okay, so that is where the 12 Angry Men research comes in. Okay, so the other thing I want to mention about the one lone minority opinion person is that if they were confident and persistent and competent, perceived as that by the other juror members, they were able to change the opinion of the majority opinion 32% of the time. But how often does that occur? Not very frequently, okay? The other thing I wanted to talk about with the jury is stress. So sometimes juries experience stress just like any other cases, but especially so in capital cases. And that's because they are forced to look at capital cases that are stressful, that are heinous, that are brutal, that even all the TV in the world doesn't prepare them to see the real victim and the real costs of a homicide or some other sort of case. So it's also true, it's also more true if they are sequestered, because then there's no escape from it, okay? So jurors have reported a number of symptoms following very hideous cases that they have to sit through, including depression, sleep disturbances, headaches, sexual problems, and something similar to post-traumatic stress disorders, nightmares and things like that, okay? And so we found that in sequestration, being forced to watch those things and being unable to leave that level of aggression and anger also occurs with those types of jurors, and it's probably because they're having to deal with it, against their will. So that results in more conviction-prone, angry sorts of decisions. So psychologists have to really kind of look at that. There have been some judges that will have a counselor available to jurors who do experience stress or nightmares or things like that. And I even saw a lawsuit, couple of lawsuits from the jurors against the court system for having to, go through that sort of thing and putting them through that, which is not good because you need jurors, and if the jurors start feeling betrayed by the very system that they are trying to, be a part of, that's not good for the rest of us in society. These are, like I said, these are particularly true for capital cases. In Spaziano versus Florida, the Supreme Court was very specific about the jury being the conscience of the community, and this is especially important of the death penalty cases. In Harris v. Alabama, they upheld the constitutionality of the judge imposing a sentence of death even if the jury chooses life. So that's another complication. What if there's two types of juries. There's a decisional jury, they make the decision, and that decision stands. And then there's a recommending jury. A recommending jury recommends to the judge what should happen. And then the judge can either go with what the jury said, or give their own disposition of the case. But the Supreme Court has been very clear that the jury should be the conscience of the community. So even though that's a recommendational jury, judges have been reluctant to go against jury decisions as well. So the death penalty has waxed and waned in the United States. It has gone from being, something that we support fully to we had a moratorium on the death penalty at one point because they found it to be unconstitutional, a violation of the Supreme Court, not on moral grounds. We could still kill people, that was okay, but on the way that it was carried out, on the way of who received a death penalty. They said sometimes that was done capriciously, or on who got to hear the case. And Witherspoon versus Illinois v. Illinois, we had people who said, I cannot give the death penalty under any circumstances, so they got rid of all those people. They called them Witherspoon excludables, and those people who could hear the case were called death qualified. But researchers point out that death qualification, being a death qualified juror, allows you to commit to say ahead of time, before you hear any of the evidence, that you can and will give the death penalty if you find that to be true. So do look on the handout that I give you about guilt nullifiers. They say I'm not going to find the person guilty if I know you're going to sentence them to death. And then penalty nullifiers who say I can't sentence a person to death as well. So in the pages of the handout that I'm going to give you on death qualification, that covers how jurors look at death qualification too, and that goes through to the end of the chapter that's going to be handed out to you. So please read those as well. So that's the jury composition and the jury's decision. That's what I was going to go over in class. And the third thing is going to be, of course, the judges, how the judges interpret that sort of thing. So do read that chapter as well. That's chapter 11, and that'll all be up on Moodle. And then when we come back, we're gonna go over civil law, and we're going to look at some films that depict actual civil law cases that are completely shocking, and I hope you enjoy those. So I will see you next time. This was for this week, and I will assign a film for you for next week. So see you on Moodle.